So, DeDe, thank you for joining us today. We're going to talk a little bit about probate in Newport Beach, Costa Mesa, and Irvine, and learn a little bit about it, how long it takes, and what it really costs to someone who has had their property go into probate. So, for those who've never been through it, what exactly is probate? We hear that word all the time. Why does
Right.
it matter so much here in Orange County in these locations?
So probate is the process that we determine who your natural heirs are
Mm.
and how to pass on your assets. It's a great question. I always say probate might be a four-letter word, right? Because it's a long process. It used to take a minimum of 1 year. Ever since COVID and the pandemic, we have cases that have been going through probate. We are just closing out now that were started in 2019, 2020. And of course, the courts were closed, so it made it more difficult. But right now, it's hard to predict because we don't know if there will be beneficiaries that are going to be objecting. We don't know if there will be assets that need to be found. So probate is just think about it as if you pass and you have assets that are in your name alone without any beneficiary designation, then your family is going to go through the probate process. And then the probate process, the state of California will determine who will receive your assets when you pass. So, kind of twofold. One, it's the process to determine who your natural heirs are. And two, what will they receive and how will they receive? So, the length of it can also add to complications. If you have minor children, a minor cannot receive assets. So that will trigger having to set up a guardian of the estate for minor children. So all of these different processes actually extend the time for probate.
How long does this actually take in California? And what factors, what things can speed it up or slow it down?
Absolutely. So if you find yourself in a probate situation, right, where a loved one has passed and they have assets in their name, and a lot of times it will be real estate, right? Here in Orange County, Newport Beach, Costa Mesa, we have high prices of real estate, and maybe a loved one forgot to do something about that real estate. So the process would be that someone would come forward. Maybe they have a will. Let's just pretend they have a will, and they would contact the Soto Law Group and we would prepare a petition, and the petition would be filed with Orange County courts or Riverside or possibly LA too, right? We kind of cover all of those areas. And then once you file a petition, you will not get a court date until 45 to 60 days out. And then once you get that court date, if no one contests it, right? If everyone agrees that you, as the daughter or the son, should be appointed as the executor or the administrator, then you would be appointed in that role. So it's anywhere from, 45 to 60 days. However, if someone can actually show up at the hearing, right? Your natural heirs, because they all have to receive notice. That's a big component, and maybe a heir, a sibling, doesn't like the fact that their brother or sister is going to be appointed as the executor or as the personal administrator. And then guess what? Bingo, they can actually show up at the court hearing on the day and say, I object. I do not want my brother or sister or aunt or uncle or whomever it is to come forward and be the executor or the personal administrator. So then that will delay it, and the court will give them at least another 30 days to file a competing petition. And so then that is where it can get delayed. And a lot of times, if that happens, usually the court will say, okay, brother and sister, you can't decide because they have equal standing, right? They don't have any priority. We're going to appoint a professional. And then that could take another 30 days because both sides have to maybe submit two or three professionals to serve. And then they have to keep narrowing it down because only, one professional would step in. And of course, that's going to cost more. But that's sort of the process just to get started.
You've mentioned a couple times like when the will is contested, and you mentioned what happens. But what happens if there's no will? Like what is the process and how does it change?
Well, it's the only difference is that you would file a petition and somebody has to come forward, whether it's, the sibling, the son, the daughter, brother, sister, someone has to come forward and be appointed. And so the difference really is that when you go to do the final distribution, when you're distributing the assets, the state of California basically says who will get what, right? If you're married, was it community property? Then a majority will go to your surviving spouse. If it was your separate property, then the surviving spouse gets some, your kids get some, right? So the state of California will decide how your assets are going to be distributed. That's the biggest difference between a will and no will, right? A will does not avoid probate. I always tell people, if they don't walk out of here without, one piece of information, is that a will does not avoid probate. So many times people just want to save money and they just say, I'm just going to do a will. Where in reality, they actually need a trust. And I know we'll talk about a trust later, but a will does not avoid probate. But the difference is who gets your assets. A will direct, if it's done correctly, will direct who will receive your assets versus intestate succession is the state of California decides who will receive your assets.
What is this all going to cost? Like, what
Yeah.
does going through probate actually cost in California? What should we expect to pay?
Well, on average, it's about 5% of the fair market value of the totality of all your assets, right? So if you have depending on how large your estate is and what everything appraises for, then that will determine how much your costs are. For attorneys and for executors or personal administrators, there's a statutory fee that both of them are able to receive. And that statutory fee is the first 4%. The first 100,000, you receive 4%. The second 100,000, you receive 3%. Then the 2% from 800,000 or more, then 1%, 9 million, and then a half a percent at 15 million. So those are the fees, the statutory fees that the administrator and the attorney will receive. And again, it's the fair market value. So ballpark, because you have to publish in the newspaper. Usually that's about $500 to publish. And then every time you file a petition, it's 475, 525. So overall, it's about 5% of the fair market value.
Okay, and so that also includes like that percentage includes like court filing fees, appraisals, things like that as well.
Yes.
Okay,
Yes. Yeah.
that's good to know. And so if these fees are being paid to an attorney, um, where you are in Orange County, Newport Beach, how does the attorney fee work? Is it a flat fee? Is it hourly? Is it statutory?
Right, so that breakdown that I just mentioned, those are statutory fees, but then the attorney can also get extraordinary fees, and that would be if it goes into litigation, right? Or if there's something that the attorney has to do that's above and beyond the norm, then they can charge their hourly rate that's, fair and reasonable to litigate, to make sure that whatever is extraordinary, if there's real property that has to be sold, that's an extraordinary task. So that's not included in the statutory fee.